And the next topic that is going to be spoken on is the one by me. Again, I'm Brian Barnes, and it's called technical mediation. And assuming that you do choose to defend, like was being addressed by Trey and Roy, then you clearly want to give the insured a good defense, but at the least cost. And one of the things, my world is construction defect, and one of the things that is difficult is that most of the construction defect cases are multi-party, and most of them are very expensive. And there are strategies for dealing with that for whatever reason, I don't find used very much, well, really at all, in South Carolina, or North Carolina for that matter. Over the last, since about the mid-90s, I've handled construction defect cases for manufacturers of exterior claddings all over the country. It started, of course, in North Carolina with the EIFS wave of litigation. And that didn't really peter out for a very long time. And what I got exposed to, though, that was very useful and I learned a lot about, is how it's done in California. And frequently, for those of us who live in South Carolina, you don't think of California as having the right idea. But this model really works. And what I want to do is discuss it from the vantage point of the expert. Essentially, the hallmark of this technical mediation is allowing the experts to try to reach consensus about what needs to be fixed and what it's going to cost. And then the lawyers and claims people can argue about how it's going to get paid for. But a lot of the procedure is moved out in favor of substance. And the technical issues, as I'm using that term, are the things that the experts would opine on. So for example, in my case, I've got a couple of them right now at Mammoth, the ski resort area between Nevada and California. And in that case, I represent a manufacturer of manufactured stone veneer, which is the fake stone that you see on restaurants and hotels, and I've got it on my house. So needless to say, I am an apologist for MSV. I believe that it's not inherently defective, no matter what anybody says. But with respect to the way that it's done with the experts is it begins with a protocol. And the reason I say that California's sort of got it figured out, and the reason that I burdened your materials with what is behind the last tab is I really think this is useful. And I think that with an assembly of claims people like this, if you sort of got the message, the lawyers aren't going to take the leadership on this, but the claims people that are paying the bills can. And what they do in these cases, and what I just included the order that I'm working with in one of the cases, the tab is folded down. But what it's at the very back, and there's a case management order. And the key to the case management order is its attachments. The elements of this protocol are that the litigation is stayed, and all the ordinary stuff that in South Carolina we spend so much time on, filing cross claims and replying to cross claims, filing affirmative defenses, and trading standard interrogatories is all deemed done. So if you look at these materials, the Exhibit A, if you go past the case management order, Exhibit A appoints a special master, so you got somebody to ride herd on this. And you know, even in San Francisco, it's $250 an hour to have a special master. It's really not, in light of the magnitude of most of these cases, it's not very expensive. And then if you look at the next one, Exhibit B, affirmative defenses. The lawyer doesn't need to go replead all the affirmative defenses. They're done. Even for a product manufacturer, the ones I would plead, which are a lot of times different than a subcontractor or somebody else, they're in there. And you've got the liberty to add affirmative defenses if you want to, but it's really not necessary. It's deemed pled. And then the next tab, or Exhibit C, are the insurance interrogatories. How many times has a claims adjuster gotten the final evaluation and wanted to ask the lawyer, well, how much insurance does the GC have every time? Let's say that you're insured as a sub. How much insurance does that product manufacturer have? So that you get a picture of not only liability and damages, but collectability. Who's got the money to actually pay to get this thing done? Well, that's the first question that's asked. So that stuff gets done up front rather than after the evaluation letter's written and you go back to the lawyer and say, well, I need to know whether these parties are insured and how much they've got, and there's a scramble. The next one is, what's the scope of work? Instead of waiting for somebody to draft up interrogatories and send them and move to compel, the next Exhibit D is you just disclose the scope of work right up front. It's almost like somebody's got in mind an evaluation letter up front, as much as you can get with pretty easily. And then interrogatories to the plaintiffs are the last exhibit where you're listing, have there been claims, is some information, for example, that's been developed that would give you a clue into the statute of limitations. And so this framework or this protocol is done up front, and the procedural work can be skipped. Now, then you get to the good part. Oh, I did fail to say this. With there I put documents collected. What we do is have a document depository, and everybody just dumps their documents in the depository. They're imaged so that they're accessible to everybody and they're inexpensive, and the cost is shared, and so they're readily available. And if you use something like summation, you dump it right into your tool, your document management tool, and you can manipulate it and see them and study them to the degree that you need to. Like I said earlier, but I want to emphasize that the written and oral discovery is stayed, because the idea is, let's get to the substance. Let's don't horse around. As one of my favorite claims people refers to it, taking the deposition of the doorknob polisher. It's just not relevant. Let's just focus on what matters. So then what happens is you get a statement of claim, and this is where the expert comes in. And this process gets driven by the experts, where the plaintiff's expert delivers a statement of claim, and then the defense group, led by usually the general contractor's expert, puts together a response. And the GC will say to the subs, okay, you get your expert and you tell me, you defend your scope of work, because you remember that the scopes of work were already turned in and we know how it's all divided up. And then the scopes of work are aggregated and sort of negotiated. Sometimes the defense response the GC might say, well, that sub was really sorry, and the sub will say, no, I'm not. So there may be some attachments to it. But then, oh, and by the way, this list of exactly how it works with the expert is at page 20 and 21 of the material. It's 7 steps, but in view of the time, I'm not going to belabor every little bit of it. But basically, claims put out, the defense group comes back with a claim that's really driven by the expert. So you say, what's wrong? What's it going to cost to fix it? And then the lawyers, mediator, claims people get together and they figure out how much to pay for it. Probably not 100 cents on the dollar. And then if it can't work, then you go back into a regular, to some degree, modified preparation for trial. But I found it, I guess I handled my first case in the Bay Area in 1997, and they progress at a really nice pace, and it works very well. Now, if I could go to Charleston and convince everybody to do that, then honestly, there'd be a lot less busy work being done. Now, there'd be a lot less lawyering, and a lot of us would not be able to show just how deeply we understand Kennedy versus Columbia Lumber and all of those other cases. Oh, that's another thing, that even to make a motion for summary judgment, you got to ask permission. You're really focused on the substance, not the procedure. Okay. Well, let me say, before I rush off of that, any questions about that? In the back.
You mentioned asking permission for summary judgment. You can't simply file for summary judgment?
Right. Now, and of course, it depends on what the case management order says. But the idea is that you've got to write a letter to the judge explaining to him the merits of your summary judgment position, and then he'll either say, yes, I think that there's a chance that it'll be granted, or no, and he'll deny you the opportunity to make the motion. You know,
A chance? He'll say there's a chance that they'll...
well, he won't offer the opinion, but what will move him is if he sees some merit in the position you staked out, he'll say, okay, go ahead and make your motion, and then he'll consider it. So that adds a little layer, but with of extra work, but it's with the idea that we're going to weed out unnecessary motions. Because as probably most of you know, putting together a summary judgment motion can be an expensive undertaking.